Working on one screen today, so bear with me if I have any technical difficulties. I will show this here really quickly. Present. All right.
Okay. Well, good morning and welcome to Working Group 4's very first Thursday morning session. And we're not going to get into why we didn't meet on Tuesday, but we're glad to be here on Thursday morning. We've got a full agenda as per usual. Leading off with a discussion of the minutes, and you'll note that the minutes on our program today are going to be resolved offline. Last week, we had a full meeting. Marcia Moray, Representative Moray from Working Group 3 joined us in part because of our continuing discussion of extreme sentences that both Working Group 3 and Working Group 4 is considering and offering recommendations. And that sort of long-running conversation continues this morning with two very important presentations regarding habitual felon status and the death penalty. So the minutes, I've seen a draft and I think it's been circulated to staff, but I'm not sure we've gotten it out in time for it to be reviewed this morning. It will be circulated and adopted or reviewed offline. We note that we've got two special guests this morning. The Honorable Spencer Merriweather, District Attorney of Mecklenburg County, is with us. I don't think anyone has called Ken Rose honorable, but all who have known him for his long career certainly consider him honorable and distinguished. I think he's without status as he appears with us this morning. Some say he's retired. Rumor has it that he's actively engaged still in supporting all sorts of good efforts in North Carolina. So we look forward to hearing from Ken Rose this morning. We note that we do want to be timely. Thank you, Mike, for letting us know that you've got that commitment at 9 o'clock. So we're going to try to make sure that we hear from our two invited guests and engage in discussions, fulsome discussions, so that you can participate in that. With that, Mary, I know that you've been working on habitual felon status, been thinking about it. I'll leave it to you to introduce this part of the agenda and to introduce our guests.
Okay, so I've had an action-packed couple of weeks since we last met, so I'm feeling a little bit like the one time I showed up unprepared in law school and Rhoda Billings called on me. But I have chatted with some of you offline about the habitual felon issues, and I feel like so we need more information in order to come up with what I think would be a fully baked and feasible recommendation. And to that end, the staff is invited, and I'm really glad to have the district attorney from Mecklenburg County, Spencer Merriweather, to give sort of a DA's view of habitual felon. And then thank you to Michelle Hall and John Madler from the Sentencing Commission, who are back with us and can help us work through some issues relating to maybe the history of this and the grid and all of that. I do want to say that just to start out, before we get started, I sent to Mercedes, and I think she circulated to all of you a chart that was put together by a former colleague at Prisoner Legal Services who made a public comment on violent habitual felon at the September session, and it shows just how rarely it's used. 49, I believe, of the 30,000+ people in the DOC are serving violent habitual felon sentences, and some other troubling statistics about the disparities. So I think I'd really like going forward, I'd like to separate violent habitual felon from habitual felon as sort of issues of discussion, because I'm going to maybe go to the Matt Hard to have us recommend eliminating violent habitual felon for lots of reasons, including if you look at the records of those folks, they don't really differ much from the records of other folks who are serving time in the Department of Corrections. And the reality is that these folks a judge would have the discretion to sentence these folks to incredible lengths of time already. So it's not like we're going to be soft on crime if we get rid of this, what I think is a misused status offense. but that's separate. So I'd really, at this point, I'll just stop talking and would like to hear Mr. Merriweather's, DA Merriweather's thoughts on the use of habitual felon in North Carolina.
Thank you very much. And I appreciate being asked to speak here today. And I'll go ahead and condition my comments in the following ways. First, when Jasmine asked me to come and speak with you, and she told me about the topic, and she specifically mentioned the notion of the habitual felon statute and racial disparities. And I was very clear with her that I had very little data, specific to my office or even specific to the state, but that I was be happy to speak with you about my own experiences in dealing with the statute and at least locally, how we try to apply some thoughtful criteria, understanding that it is a very, it's a heavy hammer within the statute. Those of you who don't know about me, again, I've been district attorney in almost 3 years at this point in Mecklenburg County, but my first job in leadership as a prosecutor was actually as the team leader of our habitual felon prosecution unit for a good 3 years. So I'm sort of knee deep in this particular statute. One of the things that we have always tried to do here is make sure that in considering who that sentence enhancement should apply to, that there are people that we believe should be in custody for a long period of time, and there are people who qualify for the habitual statute who merely are just kind of sort of caught up in a string. A brief history about Mecklenburg: there was a time where it was within the purview of an individual prosecutor to decide whether or not to indict someone as a habitual felon. That was that policy became the substance of a legal action by a local defense attorney. The response to that legal action by Peter Gilchrist was to make the determination that every single person who qualified for the habitual felon statute would be indicted as such. And then we would work through the process of deciding who it is that we believe should be sentenced as a habitual felon. That led to the creation of a habitual felon team in my county, under which the cases for habitual felon qualifiers undergoes some of the most rigorous attention in the office, that we dig far deeper than just an individual file, but really dig into the actual history of the defendant in their record, not only of conviction, but arrest and every other thing that is asked or that we could determine about that individual defendant. To give you an example, it is very unlikely that a defendant with three convictions for I felonies or possession felonies is likely to receive a habitual sentence in Mecklenburg County. One of the things we're looking for is if it looks like what brought someone into the status of being a habitual felon qualifier is a substance use disorder. Those are the people we're trying to go after. Quite frankly, someone who's been breaking into cars is not the person that we're trying to hit with this heavy hammer. To be honest, if it's someone who's committed residential breaking and enterings, that may be someone that we're looking, depending on the circumstances of those crimes. And it's not just the fact that the crime happened, but it's our ask of each individual prosecutor to dig into the facts of that old crime to see what sort of trends exist. All of that information is brought to sort of a common clearinghouse in our own office for those people assigned to that team to discuss openly. The goal there is to try to develop a level of consistency on how we apply the statute when we decide to seek full habitual sentences. When we did not have the benefit of that, it was all over the map. And I think that lack of consistency is something that was certainly bad for defendants, bad for the system, bad for the defense bar as far as their expectations of what their clients were walking into. And so that's something that we tried to eliminate. Most of the time that I have been exposed to the habitual felon statute has been in a post-Justice Reinvestment Act world. So the old days of taking the Class I felony and immediately vaulting to a Class C felony exposure is not something that that I worked with directly. So most of us are used to, 4 classes up. I'm also used to the existence of some intermediate exposure before we get all the way up to full habitual felon status. The presence of the habitual breaking and entering statute has been extremely helpful for my office, and I certainly believe for the defense bar, as sort of an intermediate option for people that you don't want to have feel the full bore and don't need necessarily the full bore of accountability and imprisonment, even though they may be habitual felon qualifiers. The presence of those options has been good for us. We still do have probably anywhere from about 80 to 90 defendants out of the probably good 1,000 defendants that are reviewed by that team. About 80 or 90 are actually convicted as habitual felon with a habitual felon status in Mecklenburg County. Within the last 2 years, I made the decision to take people who have been charged with simple possession and not review them for habitual felon qualifier status by our habitual felon team. The idea being that if you're charged with simple possession, you're really not who our team is after. So they stay with the folks in our office that review drug cases in our office. If for some reason there is some special nexus to violence, haven't ruled out the possibility of proceeding with the habitual felon statute against those folks. But by trying to change our systems, internal systems, to not really tag people with that status who are really just suffering from a substance use disorder, that has been a win for us and allows us to devote our attention to the cases that we really believe do need the possibility of that exposure. So anyway, I just wanted to introduce at least some of those, some of the types of things that we think about, some of the attention that we try to give to these cases to make sure that we're not indiscriminate in the way that we apply the statute. And, some of the ways that the changes over the course of the last, 8 years at this point, have really added to the level of review that we give to these cases. But I'm happy to answer any questions that you might have.
DA Merriweather, does your office have any written policies or guidelines that you'd be willing to share?
Yeah, I think the reason I say that is because I wrote one many years ago, and it has changed significantly as our conversations sort of have changed in the office. But I believe that there's a new format. The leader of that team right now is a woman by the name of Gabrielle Kelly, and I'd be happy to share it with you. I'll lay hands on it. A lot of it's going to be inside baseball, and most of it will have to do with our, excuse my terms, crazy ass administrative system in Mecklenburg County, and little to do with, and Judge Thornburg knows exactly what I'm talking about, but little to do with the sort of substance of review, but be happy to turn that over to you.
Okay.
Spencer, I'm curious whether or not you're familiar with Brandon Garrett's recent study that was published regarding extreme sentences and habitual felon sentences. I know of your interest in data, and it seemed like Garrett and the folks at Duke had spent some considerable resources looking at statewide numbers, and wonder if you were familiar with that.
A little bit, and one of the things that we've tried to do with Brandon is we have invited the Wilson Center to come in and review our roundtabling process, which is that clearinghouse that I was talking about. As a matter of fact, members of his staff have already come in and taken a look, and I think we're somewhat surprised at the detailed review that we're given in these cases. I think that because I think they wanted to do a larger look at the way that prosecutors, determine plea arrangements and make plea offers. And I think, so that I'm not sure that the habitual felon prosecution in our office will be the corpus of their study, but I think that, Brandon has been engaged with our office specifically on this topic. One of the things if it wasn't Brandon, I believe it was someone else at the Wilson Center who was surprised about was that when we make plea arrangements, almost 98% of the plea arrangements that are offered where we do offer habitual felon status within the plea arrangement, that it's offered at the bottom of the mitigated range. And the idea behind that is we do recognize that it's a heavy hammer. We're trying to give folks every opportunity to receive the benefit of resolving their case in the early stage in prosecution. I think there are certainly some other places where, they'd be looking at, at least consecutive offers and offers, in a presumptive range. And for us, that's not, we recognize the tool that we're dealing with, and we're trying to give everyone, everyone the same benefit of the doubt.
Yeah, I think that identifies one of the concerns that we have as a task force looking at statewide practices. And you identified the very unique history of Mecklenburg County on habitual felons. And there was a time that I would have remembered the case that you referred to by name. I certainly remember living through that experience. But I do believe that the Mecklenburg County has a different tack towards habitual felon and status. And I think what the Garrett Wilson Center research has demonstrated is across the state, the same approach is not taken. And what we're looking at are very disparate sentences, racially disparate sentences. I think combining what Ben Finholt showed from the Justice Sentencing, I'm mangling the name, Mary, but the sentencing project that Ben Finholt represented and Brandon's number suggests that it's in this area where racial disparities are at its highest. And they're at its highest because the degree of prosecutorial discretion is at its highest. And what we're finding is that nowhere but Mecklenburg County almost nowhere but Mecklenburg County are there protocols in place, systems in place to sort of guide that discretion in an effective way. So I think the data causes us concerns about how we can address these disparities.
On that note, we have the sentencing and sentencing commission folks on the line that have some slides, I believe, that might speak to some of the questions that we had last week on that. It might be a good opportunity for them to jump in. Michelle and John, not sure if you guys wanted to share your screen.
Sure. Good morning. This is Michelle from the Sentencing Commission. Can you all hear me okay?
Good morning. Yes.
Okay, let me pull up a slide deck. I know Mary had mentioned that we might be talking about the grid and the history of the habitual felon status, but we had planned to share some data on habitual felon status offenders separate from the violent habitual felon convictions, and I have both of those this morning. So hopefully this will be helpful to your all's discussion. And I'll try to move through these quickly because I'm recognizing the time on your agenda.
Thank you so much.
But just wanted to, okay, thanks, Mercedes. Just wanted to quickly note what our data source is and some of the things to keep in mind as I'm reviewing these slides. We're not looking at the pool of potential eligible charges for habitual felons. We are looking at those that have been convicted and sentenced as habitual felons. And the data that we're going to feature today come from our statistical report, which includes information on convictions and sentences imposed. It's statewide data. It comes from AOC's data management system. And our unit of analysis, while I'm referring to it as a conviction, it's really a sentencing episode, which is identified from court records as the sentence imposed for the most serious conviction on a given day of court. So that's just something to keep in mind. We're looking at our most recent year of data, 2019, and some trend data, sort of going back in some cases as far as our historical data allows. So just as context, we wanted to share some general statistics trends on total felony convictions from the late 90s to today. And you can see that there's been a pretty dramatic shift when you look at particularly 2 points in time, 1996 to the current year, in terms of the percentage by race category. You can see that the percentage of white offenders is increasing, while the percentage of Black offenders as a percentage of total felony convictions is decreasing. And our other category, which would include the smaller race categories, is sort of holding steady throughout that period. So just as context, because when we switch to looking at only habitual felon convictions, which I'll do now, I'll go to this trend slide first. We can see sort of a similar trend. Unfortunately, can't go back as early as the felony convictions as I just showed you. But from 2000 to now, we can see those shifts occurring similar to our total felony conviction trend. I just want to also show just sort of a trend in the pure number of habitual felon convictions. We've been seeing a pretty steady increase since 2012. And last year, FY19 was the first decrease that we have seen since that time, and it was a pretty large decrease of 12%. We expect to see a pretty significant decrease again this year, which we can attribute in part to COVID and courts being closed. Sorry, I just realized I was not sharing my video. Okay, so also just taking a look at any differences between white and non-white in terms of habitual felon convictions and what the most serious substantive offense was that was associated with that habitual felon conviction. And you can see generally what we would expect is that most of them are in the lower level offense classes, and most are property or drug offenses. But the specific offenses do vary a little bit when you're looking at differences between white and non-white. DA Merriweather mentioned the Justice Reinvestment Act and some of the changes that occurred to the habitual felon law during that time. And what that did was made the punishment more proportional with the underlying offense instead of automatically being convicted and sentenced in Class C. So what we've done here on this slide is to try and look at any differences between white and non-white in terms of who is convicted in the harshest, the most serious offense class, and how that has changed since Justice Reinvestment classification changes in 2011. So you can see that, while the percentage sentence in Class C decreased overall, and for both white and non-white, a greater percentage of non-white are still being sentenced in Class C compared to white. But when we look at the actual sentences imposed, we do see that there are minimal differences in the average minimum sentence imposed when you look at white and non-white and compare them by class, sort of by design of the grid, but we don't see large differences between the actual sentences that are being served. Switching over to look really quickly at who is incarcerated as of June 30th, 2020 as a habitual felon, and sort of the race breakdown there compared to the overall prison population. So the pie on the left side just shows the racial breakdown, white and non-white, as of June 30th, and you can see it's 60-40. And then when we look at the specific group of habitual felons that are incarcerated within prison, it's a very similar percentage, 62% non-white, 38% white. So this is just a different way of looking at this group. Previously, we're looking at who's convicted and sentenced, and this is the group that's incarcerated as of June 30th. So just some key summary points to leave you all with, because I know we don't really have a chance to dig into too detailed on some of these data points. But we have some numbers in terms of how many have been convicted as habitual felons, and recognizing that FY19 was the first time we actually saw a decrease in the number of convictions. We put some information in here about charges, and this is not, as I mentioned, the pool of charges generally. It's charges that ultimately resulted in conviction. And so about 8% of the time for white and 13% of the time for non-white, they might have been charged as habitual felon, but they were ultimately convicted of something else. And usually it was an underlying offense or another habitual offense, like habitual B&E, for example. And just quickly reiterating the points about the changes in race composition over time, similar to felony convictions, the percentage of white is increasing while the percentage of Black is decreasing as a percentage of the total of habitual felon convictions. And then again, the sentence lengths being similar, we also looked at the phenomenon that DA Merriweather described with mitigated sentences. We do see generally that habitual felons often receive sentences in the mitigated range. We didn't necessarily see any differences by race in terms of, you know, sentences in the presumptive or mitigated range when we were looking to see if that was something to share with you all. There wasn't any variation there. And then lastly, again, the percentage of the habitual felons in prison by race is similar to that of the total prison population. I do have just one quick slide about violent habitual felons, which I think you all have pretty much reviewed already at this point. This is, again, coming from our conviction data, and we looked historically at the total number of convictions over the past 19 years of violent habitual felons, and we don't really see that many on an annual basis. It's an average of about 3 per year. So total, we saw 53 convictions over the past 19 years. And again, all were male, and a large percentage were non-white, 79% were non-white. And then we just have a list of some of the most frequent underlying convictions for those that were sentenced as violent habitual felons. So I'd be happy to answer any questions about regular habitual felons, for lack of a better word, or violent habitual felons, if you have any questions about the data, or if you have any questions about the history. John is on the call too, so he could answer those as well.
Thank you, Michelle. We'll reserve just a few minutes for questions of members.
Henderson, if I can ask Michelle, I know the sample size of the violent habitual felons is much smaller, but is there a trend line? Have you graphed that over the 20 years as the non-violent habitual felons? Has there been any difference in the composition? I know it's still 79-21.
No, we hadn't graphed it in that same way, but we certainly could. We certainly could do that. There's just so few per year, but so it might look a little bit strange, but we could certainly put that together and share it with the working group if that would be of interest. So you mean doing something along these lines, this chart, but looking at just the violent habituals?
Thanks.
But also, I don't know if this is possible, but I'd be curious about sort of the comparison of people who were eligible to be indicted as violent habitual felons. I'm going to have to let me think more about how I'm going to phrase that question. I just, yeah.
I want to ask DA Merriweather question. I had asked that we have input from the prosecutor, so I'm glad you're here. I guess 2 questions. One, if you did not have the habitual felon tool, do you think you could reach, do you have sufficient discretion and tools to reach what you believe to be fair outcomes. Number one, and number two, I would like to hear your view on this. What would you like to leave us with? What's the takeaway?
Oh, you're muted.
Yeah,
Merriweather.
The habitual felon statute does give our folks a lot more latitude and a lot gives us the opportunity to put together some really creative sentences and pinpoint exactly what it is we're looking to achieve. And so to that extent, it is something that I favor. It's funny, like I looked at one of the slides from the Sentencing Commission and I saw that for trafficking, and I think it said trafficking in opium was one of the more common sentences associated with habitual felon prosecution. And if we were just talking about giving people the most, the most prison time we could, that wouldn't make any sense. I look at that as someone who's been dealing with this statute for 4 years, and I can see that someone decided to habitualize the trafficking statute to pull someone out of the mandatory minimum so that they could actually have probably about a year and a half less than they would have gotten otherwise. There are people who know this statute who are working with it a good bit, know how to use it pretty surgically. I'm not saying that happens everywhere, but they know how to use it very well, and that latitude is something that has been helpful. I do agree, and just to rip the Band-Aid off, I know that if we are really thinking about trying to make sure that the impact of imprisonment and incarceration in our state is not racially disparate, you have to have some consideration of the fact that there are some people who are more likely to have engagement with police than others. And that is very likely to end up in with people having a different conviction record than others. I hope that the way in which we have chosen to consider the types of things that are in a conviction record versus others helps that. If there are ways that value can be sort of spread over the state, then I think that would be value added to the statute. But I can tell you, I got a lot of people who live in vulnerable neighborhoods who are breathing down my neck, and not in a bad way. It's just they're telling me, like, I've got just as much of a reason to live, in peace and dignity as anyone else. And your system keeps sending back the same person who commits the same thing over and over and over again, who's threatening my house and my kid. And the presence of an enhanced statute to help give those folks some peace is a big deal. Now that means that it's that much more important for me and other actors in the court system to be sure that they're using common sense and restraint in how they do it. But as far as the statute actually existing, yeah, that's something I need.
I think Ben Finnell identified this as one of the areas of most unregulated discretion in our system, where this discretion is reposed only with the DA or exclusively with the DA. And when you look at, for violent habitual felon, 80% African Americans. When you look at habitual felon status at 60 and 62% persons of color, the connection between that unregulated discretion and racial disparities can't be denied. And Mecklenburg County is considered the 51st state for a lot of reasons. And one of them is when we look at how that discretion has been exercised, it explains the racial disparities. And so the question, one of the questions we have to wrestle with is, looking at the criminal statute, the criminal code, do you and do district attorneys have sufficient tools to respond to any criminal threat? And whether or not, a code with as many provisions as you've got, whether we need this hammer, which may especially outside of Mecklenburg County, be wielded in a way that sort of adds to the disparities. What a fabulous, I'm sorry, Mary, I don't want to interrupt.
No, I think this was all really informative and really helpful. And I would really like to see DA Merriweather's guidelines. There's like a range of things here, right? There's we leave everything the way it is. We get rid of habitual felon. Are there things we can do to help guide that discretion where it maybe isn't being exercised as responsibly as it might be by DA Merriweather, for example, put an age limit on use of prior felonies or take out substance use things. I don't know. I think this is a great presentation by both DA Merriweather and by the sentencing folks, and we'll have to look through this all and think through this some more. So that's
amen to that. It was a fabulous discussion. Thank you, Spencer. Michelle, thank you so much. I think we're going to have to dispatch any introductions. Just looking at the clock, Ken, I think we've cheated you out of a couple of minutes here. So let me just introduce my good friend, mentor, and hero, Ken Rose, of no portfolio at present. But Ken has agreed to help us think through our own experience with the death penalty over 40 years, the ups and mostly the downs in that history, and to help us think through the impact of the death penalty on the concerns of racial disparities in our criminal justice system. Ken?
Yeah, thank you, Henderson. I appreciate it. Thank you to the members of the committee, and I appreciate the invitation to speak to you this morning. For those who don't know me, I'm going to tell you a little bit about my history as a capital defense lawyer, including my work with groups that help pass the Racial Justice Act. And then I'm going to talk about North Carolina's limitation on prosecutorial discretion that uniquely positions state actors, prosecutors, to act arbitrarily and discriminatorily by prohibiting them from exercising independent judgment in determining who deserved the death penalty and who did not. And in some ways, it's the opposite of your earlier discussion on habitual offender, where prosecutors have unbridled discretion to use that statute where they think the penalty might be appropriate. In North Carolina, beginning in 1977, prosecutors had no discretion to decide whether or not to pursue the death penalty in cases of first-degree murder where there was an evidence of an aggravating circumstance. So I will talk about that. And finally, I'll talk about some recommendations. I began practicing capital law, capital punishment defense law in Georgia in 1981, and I had the privilege of witnessing Jack Boger and David Baldus in their landmark study of racial discrimination, the application of the death penalty in Georgia. I practiced there for 3 years. I then went to Mississippi, where I practiced for 5 years. And as you might imagine, racial discrimination was not subtle in my experience in the use of the death penalty in either Georgia or Mississippi. And I have some slides that I want to try to share with you, if I may. See if this works. Okay, this is lynchings of persons between 1883 and 1940. And then And this is executions of persons, of Black defendants between 1972 and 2020. So you see they're matched. And we knew this in Mississippi and Georgia 30 years ago. We knew that where persons were lynched, persons were executed. And it's no coincidence that that is occurring in the Deep South, in Texas, and in North Carolina, South Carolina, Virginia. Now, the interesting part is the next slide. So this first slide is where the states that pretty much never had a death penalty after Furman versus Georgia. And that's, I believe, 1990. And the second slide is the current set of states that have the death penalty. You could be excused if you're looking at that slide 2 days after the election and you think, well, those are the states that Joe Biden won. In fact, it's almost identical. And I don't think that's a coincidence either. I think that there is, if you think about the states where there were lynchings, and you think about the states that have executed Black defendants, it's the states that haven't done that have abolished the death penalty. And there are Western states involved in that as well, but in fact, those states have almost no one on death row. If you look at Nebraska, Wyoming, North Dakota, South Dakota, they have death sentences, but they don't use them. So it's really the Deep South. It's where Black persons are, and it's where Black persons are controlled by the criminal justice system that we have and we use the death penalty. So, and I started practicing capital law in North Carolina in 1989. And at that time, the North Carolina courts had made some efforts to address racial discrimination in the criminal justice system. For example, in counties with a history of never appointing a Black person as grand jury foreperson, the court found that racial discrimination required a reckoning. And the court actually took action against that and used the state constitution to do so. But when it came to ensuring that Black persons served on juries that decided the fates of criminal defendants, the North Carolina courts were missing in action. In fact, after denying hundreds of appeals, it wasn't until August 14th, 2020, in the case of State versus Marcus Robinson, that any North Carolina appellate court granted any criminal defendant relief based on the state's discriminatory use of peremptory strikes against a Black prospective juror. And of course, the court grounded that decision in State versus Robinson on the Racial Justice Act, which you all are aware of. And I wanted to commend this committee for its recommendation to reenact the Racial Justice Act and apply it to capital cases, but also the recommendation to study its application to life sentences. It's not quite accurate to say that the North Carolina Supreme Court did nothing to address concerns about racial discrimination in the criminal justice system until 2020. But instead of confronting racism directly by condemning racial discrimination in jury selection and sentencing, the court adopted a novel rule restricting prosecutorial discretion. In theory, if prosecutors had no power to choose which defendants were subject to the death penalty, they could not discriminate by race or any other factor. Discretion is a central part of the prosecutor's role under our state law and constitution. You heard DA Merriweather talk about how important it was to him to have discretion in crafting fair sentences. And also, discretion of prosecutors is a fundamental linchpin to the United States Supreme Court's regulation of capital punishment schemes since 1976. In Gregg versus Georgia, the court stated for plurality of the court stated that a capital punishment system requiring that prosecutors refuse to plea bargain would be totally unrealistic and totally alien to our notions of justice. The court repeated that in McCluskey versus Kemp. And yet, North Carolina became the first and only state in the modern death penalty era that prohibited prosecutors from offering plea bargains in first-degree murder cases with evidence of a single aggravating circumstance. Further, prosecutors could not consider individual facts or circumstances of the crime or the defendant in deciding whether or not to seek the death penalty. This quasi-mandatory scheme prevented prosecutors whose decisions guided every aspect of the criminal justice system from considering the individual defendant before them, like North Carolina's previous mandatory death penalty. The prior mandatory law required a death sentence for all first-degree murders. In Woodson versus North Carolina, the US Supreme Court struck down that law because it violated the Eighth Amendment by prohibiting the consideration of the diverse frailties of humankind. But the 1977-2001 quasi-mandatory scheme prevented prosecutors from weighing this very kind of evidence. And in practice, it constrained every other actor in the criminal punishment system. Prosecutors could not consider a defendant's lesser role in the crime, age, intellectual disability, severe mental illness, or even the fact that the defendant demonstrated remorse and pled guilty as reasons not to seek the death penalty. People of color bore the brunt of these limitations on prosecutors. And I'm gonna jump down to slide. So here it is, a slide. These are some slides that Gretchen Engel presented, but in a different form, showing how different categories of persons on death row were heavily weighted toward people of color. And in this slide, it shows that people of color, 9 persons of color have been exonerated from death row, 1 white person. But this slide also shows when those persons were put on death row. All 10 of these people were put on death row before 2001. And part of the reason is because of the limitations on prosecutorial discretion. The second slide shows, it shows pre-DA discretion before 2001, non-shooter death penalties. There were 4, and those were all people of color. Persons with intellectual disabilities, 16 persons of color, and 2 white persons, all before the onset of DA discretion. Death sentences for unpremeditated murder, 6 were put on death row, 6 persons of color before DA discretion and 2 after DA discretion. And for children, 3 persons of color were put on death row before DAs had the discretion to consider the age of the defendants, 1 white person, and then after DA discretion and before that was actually found unconstitutional, 1 person of color was put on death row. And finally, I don't have this data broken down by race, but an amazing number of people pled guilty, acknowledged their responsibility for the crime, 28 people, before DAs had the discretion to consider that fact as a basis not to seek the death penalty. 28 people pled guilty and yet were sentenced to death. And after 2001, just a single person who pled guilty was sentenced to death in North Carolina. So this is all to say that we have a huge amount of problems with prosecutors who don't have the ability to consider the background and history of defendants who are limited in their ability to consider those things, and aren't able to make an independent decision whether the death penalty is appropriate. We handcuff those prosecutors. I want to give one example of a defendant who was pre-discretion, and that is Leon Brown. Leon Brown was 15 years old when he was arrested for his alleged role as an accessory to the brutal rape and murder of 11-year-old Sabrina Bowie. Because of the brutality of the crime, the prosecutor decided to try Leon Brown for first-degree murder. Once the prosecutor made the decision to pursue a first-degree murder conviction, he had no choice but to seek the death penalty. He could not consider Brown's age of 15. He could not consider Brown's lesser role in the crime as revealed in his confession. He could not consider Brown's IQ in the low 50s, and he could not consider that Brown suffered from a severe mental illness. In short, the prosecutor had no discretion to consider any mitigation. Leon Brown was, as a result, sentenced to death for his role, later resentenced to life imprisonment, and it took 30 years for him to be exonerated through the intervention of the Innocence Inquiry Commission. Perhaps most shockingly, North Carolina was the only state in the country with these limits on prosecutorial discretion, and these limits clashed with prosecutors' most fundamental constitutional and ethical obligation, and that is to do justice. Prosecutors were barred from telling jurors that the evidence showed that mitigating circumstances outweighed aggravating circumstances, and instead, prosecutors were required to argue that the evidence supported the death penalty, even when they believed it did not. The results were disastrous. North Carolina became the second highest per capita death sentencing state in the country during the mid to late 1990s. Who would not in other states, the limitations on prosecutorial discretion exacerbated rather than cured racial discrimination. And of course, studies have shown that in the 1990s, studies by Dean Boger and Professor Una and others have shown that pervasive racial discrimination by race of the victims reached its zenith in the 1990s. Finally, in 2001, the North Carolina legislature mercifully ended our experiment with a quasi-mandatory death sentencing scheme. But the legacy of that tragic experiment remains. 43 people were executed under that scheme, and over 2/3 of North Carolina's current death row were sentenced before the repeal. So what do we do about it? Now I'm gonna suggest some recommendations. This just shows 10 innocent people on North Carolina's death row. There's a couple things that we can consider. We absolutely should consider abolishing the death penalty. We have already seen uncommon foresight encouraged by both the North Carolina General Assembly and the North Carolina Supreme Court in their creation and review of the Racial Justice Act. And I believe that eventually the legislature could repeal and should repeal the death penalty. But legislative abolition is just one of the potential remedies to the unfair application of the death penalty. Prosecutors, including the Attorney General in post-conviction cases, have the power and indeed the duty to acknowledge racial discrimination and other injustices in capital cases. The duty to do justice includes confessing error in cases involving systematic injustice. Similarly, North Carolina governors have the unbridled constitutional power to commute unjust sentences. Governors in other jurisdictions have done just that, and I show this slide, have done just that when faced with systematic unfairness. I propose as a start that Governor Cooper commute all death sentences rendered during the period when prosecutors had no discretion to consider the diverse frailties of humankind when determining who lives and who dies. And so I'm gonna conclude with that. And if anyone has any questions, I'll be happy to address them.
Thank you, Ken, for that extraordinary walk through 40 years of history and through the issues that sort of face this working group and the task force. I'd open up the floor to members for questions or comments. Yeah, I'd like to say that this was all entirely thought out, Ken, having you and DA Merriweather have a discourse on the centrality of district attorney or prosecutorial discretion. Yeah, I think that was just sort of a bonus of having this very reflective conversation on extreme sentences, racial disparities, and how we get there. And North Carolina's fairly unique statutory construction of the death penalty and how that fell in. So thank you for that really nuanced discourse. Yeah, the dividing line that you identify occurred. What were the changes that occurred in the 2000-2001 time period that so dramatically changed things in North Carolina? Was discretion the only legislative change?
No, there were IDS was created in 2001, and that made a huge difference in terms of setting standards for capital trial counsel. There was a bill that abolished the death penalty for people with intellectual disability that was passed in 2001. And not long after that, there were several reforms about eyewitness ID, creation of the Actual Innocence Inquiry Commission, and other things that actually helped to create some important safeguards about convicting innocent people. So we've had a series of reforms that have mattered, but it hadn't, those for the most part came too late for the people that 2/3 of death row that is there before 2001.
I'm remembering a history and a culture of trial by ambush that even affected capital cases, and that the open file discovery was introduced in that same sort of general time period, such that investigations both at trial and in post-conviction were dramatically different for cases that were litigated post-2001. And so there really does seem to be a recurring theme that death sentences that were imposed in before 2001 are sentences that would not be imposed either in the modern time period today or at any point after 2001.
We went from the second highest rate of sentencing people to death in the country to the bottom third after 2001. So an amazing drop directly related to these reforms, clearly indicating that persons who had been sentenced before 2001 would not have been, many of the persons, not all of them, but many of them would not have been sentenced to death had there been these reforms in place.
I know we're looking at the clock, and we've got an agenda that takes us at least through 15 minutes of this. I would say two things. One is that you touched on the RJA, and I think that Gretchen described the costs that we're looking forward, and that I guess Mary Pollard is going to have to identify the funds for litigating somewhere between 130 and 140 Racial Justice Act petitions. And it sort of confronts us with this choice. Do we acknowledge and identify this history of systematic discrimination, or do we invest in 130, 140 evidentiary hearings? So there are a lot of questions. I would ask, Ken, We have a specially scheduled working group session next week, Tuesday. Professor Jim Coleman is going to address our death penalty recommendations, and we're inviting the entire task force to join us at that hearing. I would ask that you make yourself, and I know that you will, make yourself available to work with the working group and with Professor Coleman so that we can work both the language and the concepts of how we go forward to address the sort of unique example of extreme sentencing, wrongful convictions, wrongful sentencings, and how the death penalty is sort of central to those concerns. So thank you for your participation this morning, and thank you in advance for your help during the week ahead of us as we try to craft the recommendations.
Thank you. It's been my honor and privilege, Henderson. I appreciate it.
Yes. Mercedes, I know that we've got a lot of work and you've now been collapsed to do that in 13 minutes. Yeah, we've been a busy working group. Help us understand where our work has left us and what we've got to do in the time ahead.
Okay, so I'm going to try to recap as best as I can on the fly. Tomorrow, our fines and fees recommendations are going to be going to the task force for a full vote. There were substantive enough changes to our prison discipline recommendation that if you guys bear with me, I'm going to share real quick. I do think we have time to look at these recommendations. This is, if I know how to use my computer, then we might be able to figure it out. Actually, here. Just click on the link, it'll pull up. You guys will see here, as soon as it fully loads, we had some language changes to specifically recommendation 5 was expanded to include much more specific language regarding an entirely new recommendation regarding an offender maternity leave program, and then specifically a recommendation regarding funding for DHSR to be able to conduct their inspections in jails and prisons and provide technical assistance on doing that. And this is all related to also encouraging DHHS to adopt rules and possibly work with jails and when they're updating their operations manuals to include provisions related to pregnant individuals, because they're not specific in that respect right now, which relates back up. I'm kind of going backwards in these, and I'm looking at again under recommendation 5.1 is DPS does have a use of force policy that specifically addresses not restraining pregnant individuals, and where the recommendation there is to enact that into state law.
Mercedes, this is Josh with a quick question. Does that also apply to jails? Yes. Next one. I see it. Sorry.
Yes. And that was the primary change under this. What we needed to know, and I'm going to switch back screens, or try to at least. Again, working with this computer. Where did my PowerPoint go? Oh no, I lost the PowerPoint. There we go. We need to approve this new language in order to put it forward to a straw poll for the task force, hopefully on Monday, with the hopes of it going to a final vote on the 13 meeting. So I don't know if you guys want to do that now.
Well, let's do that now. Do we have a motion to approve?
Other people are different.
Well, if there's a substantive hesitation, we may need to put it all to offline discussion. I know that we may have lost Mike. Is Judge Thornburg still with us? I can't see him on the gallery.
I'm looking as well.
It might be that we don't have enough
Sure.
members to do that. And
Okay, that's fine. It seems like we might be having to do a survey offline here. So
Right.
I might try to encapsulate a lot of our, like a post-meeting survey, if you will.
Right.
So moving on here to the next one, collateral consequences. Basically got consensus on all of those for the people that did vote. We are kind of at a toss-up on whether the recommendation should be restoring voting rights regardless of felony incarceration status, or just for those on probation. They both got rated above 4. It was like one got 4 and the other one got 4.3. So I think that's one question that needs to be answered. I pulled out the recommendations related to reentry into its own recommendation so that we could have a little bit more of a specific problem statement as it relates to that. And I think the question there is, do we want to specifically enumerate each of the SRCC recommendations? And I see that I'm gathering that we probably don't, but maybe would we want to have a recommendation stating an overarching, support for the recommendations as they come out of the SRCC, which is a continuing body, right? So their recommendations are kind of always being updated to a certain degree. So that we'll talk about offline as well. We had some updates with respect to our redressing sentences. So the options that we talked about today with respect to habitual felon, all the various options, I'm gonna maybe put a survey together, talk about that. Some specific recommendations that Ken brought up, pulled that into a survey, and some other survey ideas that have popped up primarily through the ABA recommendations associated with that recommendation and the death penalty. And then, so these kind of are our final next steps. These are some dates on kind of the goals for when we might be voting on some of these things at the task force, keeping in mind that, we only have 2 more meetings. So I think that's it on the slide.
Ken, I noticed that many of your remarks, you're referring to a sheet of paper, which I assume may have been notes to guide your presentation. If those are in a shape that can be delivered to the working group, I think they would be helpful to have some version of those notes as part of the working record of the group.
Happy to send it.
Definitely, please do.
And thank you, Mercedes. I do know.
Oh wait, I'd be remiss to say that Ken was one of the first attorneys that I worked with straight out of law school, and so I have to thank him for that experience. You have kind of the learn from the greats, right? And so I think I full circle. It's good to see you again.
Well, Ken's imprimatur on lawyers across the country is pretty significant. Mary?
I just wanted to say 2 things. First of all, Ken, it's really nice to see you. It's been way too long, and I'm sorry it's on a Zoom call. Mercedes, have we gathered data on the cost? And if not, is that something we should and need to do? Because I can tell you, I have looked at the cost since I started my new job, and it makes me cry because there's so many other things we could be using those funds for. So many.
Death penalty.
Yeah.
Specifically. Yes, ma'am.
On post-conviction, on all of it. So I think it's relevant. I don't know that it's, that it's dispositive for anybody, but I think it's important that people know.
Yeah, and we make sure we include it in the report, references to it.
So Mercedes, I think I'm going to ask that we work very closely with Ken over the next few days as we're sussing through the ABA recommendations and these other recommendations. I think the time is so limited, Ken. I think if we can use these next few days to craft a set of recommendations, both incremental, aspirational, because what we've identified in this presentation is both legislative avenues, gubernatorial avenues, prosecutorial avenues to reduce the racial disparities and to blunt these extreme sentences, so that if we can get a fairly coherent set recommendations for purposes of the straw poll and for the task force recommendation, there's high value in that. So we're going to prioritize those activities over the next few days. Well, thank you all. Good morning, Justice Earls. You're popping up for the first time in the gallery. Did you have a comment?
I did. Thank you. Sorry. I know you're trying to wrap things up, and I have been here all morning, but I wanted to just, when Mary brought up the cost issue, I just wanted to ask whether we have looked at that same question in terms of the habitual felon convictions, because I will just say that I think that when those habitual felon sentences are imposed, that results in appeals, and because the time is so long, and this is anecdotal, but just my experience in the past 2 years on the court, we see cases being appealed to our level, which it seems to me it's mainly because they were habitual felon. They've got years and years and years and years. And I don't know if there's any way to address that, but I think there are costs associated with the habitual felon enhancement that are not being well understood.
Thank you for that. Mercedes, another challenge to the staff.
Noted.
But a critically important one, and it is connected to the whole range of issues connected with these extreme sentences. Well, thank you, Justice Earls.
Thank you.
Well, good. This has been an impactful and productive session. Maybe we should switch to Thursdays going forward. But I think we only have one meeting before our recommendations are due to the governor. So a lot of work over the next week or 10 days. Thank you guys. Have a great week.